This is East Idaho Newsmakers with Nate Eaton.
Welcome to East Idaho Newsmakers. Today we are talking with Attorney General Lawrence Wasden. He has been the Attorney General since 2003 and recently spent some time in Eastern Idaho meeting with a few different organizations. I'm going to start off with a question you may or may not get a lot of. What exactly does an Attorney General do?
Well, that is actually a really great question because there's a lot of confusion.
Yeah.
I'm not a policymaker. I don't change the law. What my personal view of the law really doesn't matter. What I do is two major functions. First of all, my job is to provide legal advice to state officers, state agencies, and I represent them in court. That's the two major functions that I perform. So as an example, by law, by statute, every legislator, Republican, Democrat, or anything in between, has the right to ask me a question about their office, and I'm required to render a legal opinion. That legal opinion is not my personal view. My legal opinion is a professional, objective review of the Constitution and applicable statutes to say, does it meet constitutional muster or does it not? Does it fit within the confines of the remaining statutes or not? It isn't that I am espousing my own personal political philosophy.
So we get asked sometimes or told sometimes by our viewers, the Attorney General is investigating the mayor or the city council or whomever. And then we'll reach out to your office and either get that confirmed or denied, or we don't really know sometimes. Is it something like you're going around saying, all right, we think this politician did something bad, we need to look into him, or is it someone that requests it to you?
That's what happens. I don't have the power to go out and conduct these investigations. In fact, what the statute provides is most of the criminal actions that are taken, not criminal actions, but criminal prosecutions, legal actions by prosecutors, that they have the primary responsibility. That's the county prosecuting attorney, and in misdemeanors in cities, it's the city prosecutor. I don't have the authority to step into those cases. In fact, I have to be invited in by the county prosecuting attorney. He then files a motion in district court, and the district court enters an order appointing me as the special prosecutor. It's not until then that I have authority to do something. I just don't get to go around and say, I'm going to investigate City X. I don't have the authority to do that. There are some limited instances in which I have what's called concurrent jurisdiction, that is concurrent with what the prosecutor has. It generally is in the area of environmental crimes or white-collar crimes, but I don't have primary prosecutorial authority for DUI or for domestic violence or for robberies. I don't have the primary prosecutorial authority. That's the county prosecutor.
And so if, let's say, a county commissioner, people say he's stealing money, this is just a made-up scenario, you may hear that, but until the county prosecutor says, can you please investigate it, right, you don't have the authority to actually do that.
Correct, but there's one clarification, and that is, the answer to your question is yes, except with regard to elected county officials, and that's only elected county officials. It's not the employees, it's not city officials. There's a statutory process that the legislature imposed a couple of years ago that if a citizen makes a complaint, I have an obligation to review that complaint, but it has to fit within very strict statutory structure. And then I do what's called an initial review, and I report to the prosecutor, yes, this should go forward, in which case I would be acting as the special prosecutor, or they need more training, or there's no action that should come out. So, but that's very limited because it has to be an elected county official, and I am limited in the scope of that statute.
So if someone had an issue with the county prosecutor who is an elected official, they could, as long as it fits certain qualifications, you could get that tip or that
correct
suggestion and go after it.
That is correct. But it's limited in its scope in that it has to fit within the confines of that statutory structure.
So that's one aspect of your job. The other aspect that we seem to hear a lot about, or sometimes we hear about, is the going after scams and fraud, things like that, things that impact the average person more than some of these other things.
Right. That is because by statute, the Attorney General has the responsibility to enforce the consumer protection laws. And the consumer protection laws are what's in effect. So I do have statutory authority and responsibility to do that. So matters like the Irs Scam, that is very prevalent. I actually have recordings on my phone at home of the Irs Scam, someone in an accent that I don't understand very well.
Is that the one where they say, the cops will come and haul you away today
That's
at
the
5
one.
o'clock? The cops.
Exactly.
Yeah, I mean.
Exactly. And the answer to that, it is a scam, okay? The Internal Revenue Service knows how to get hold of you. They communicate with you in writing. If you have an ongoing matter, they may phone call you, but they're not going to call you out of the blue and tell you that a warrant's going to be issued, and if you don't call, you're going to have to be arrested. That isn't how the IRS communicates. It is a scam. There's a very simple solution to that. Hang up the phone. That's how you sever that
But
communication.
how do you get them to stop calling?
That is a little more difficult. And so you can do a couple of things. One of them is contact my office online and sign up on the do not call list. That's actually controlled by the Federal Trade Commission. It started out with the states, and the federal government has taken that over. Contact the Federal Trade Commission, sign up on that. But that's not going to necessarily stop the calls from coming, but it does give you the ability to make a complaint to the FTC or to my office, in which we will try and follow that up. Sometimes it's coming from within the country, sometimes it's not. But what happens is that the more we get the complaints, the more we're able to do with that. Mm-hmm. They spoof their numbers, they do all kinds of things to try and get around that. The reason why I say that putting yourself on the no-call list is beneficial is because it gives us some tools to work with, but recognize these people don't comply with the law in the first place. And so as a consequence, they're not going to pay attention to the do not call list.
Yeah.
But what it does for us is because your number is on the do not call list, we have the tools to go forward.
And I've had some of them where I'll kind of play along. They get sometimes very crude and vulgar and use profanity and then hang up. Has that increased over the past 2 or 3 years? It seems that we didn't deal with this 5-10 years ago, or maybe we did.
Well, we did. It's just that the scammers are pretty creative. If you look at them, each scam basically has the same elements, mm-hmm. But they change the text to try and keep it fresh and catch somebody new. But what they're trying to do is they're trying to make some urgency in you. That's the first thing. That is the scare. You know, the IRS is going to come get you. They talked about the IRS. That's kind of scary anyway. Mm-hmm. And then they're going to come get you. They're going to come arrest you. And then to impose on that some critical time element so that you don't think rationally, you think in a hurry, and therefore you respond. And that's the same technique that they apply. I mean, another example is the Grandparent Scam. And that is, Johnny or Susie calls you, and I'm in the jail in Mexico or China or wherever. That you just choose the place, and I really need your help, Grandma, and can't get hold of my mom and dad, and I need some money fast right now. And, they say I've got to pay it, and if I don't, they're going to do something bad. And so Grandma then, she wants to send money to Johnny. I mean, that's what grandmas do. But what's happening is this group, the person, they're on Facebook, and they know the name of the dog, and they know your name of your little sister and all of that kind of stuff. So they're giving you cues that tell you that they're Johnny when in fact they are not Johnny. So the easiest thing to do there is hang up.
And they tell you to put on an iTunes gift card, right?
iTunes gift card, which we can't trace, can't track. So, call Johnny's mom and dad. Call Johnny. Johnny's probably in, Talladega at the International 500 or something. He's not in Acapulco or China or whatever. Yeah. So make that phone call, and if you're worried about Johnny, but recognize that it's a scam. And what they're trying to do is give you a scare. They're trying to give you limited time in which you have to react because they don't want you to think about what you're doing.
How many people are falling for these in Idaho?
Well, it happens all the time. I mean, Idaho people they're good, kind people, right? And they target primarily the older generation, who is a far more trusting generation. They didn't have people doing this kind of stuff. And, they're on the phone. They're nice people, and for them it is rude to hang up. And I will give you permission right now. It is not rude to hang up the phone. They're interfering in your life. You can hang up that phone, and don't think twice about it.
Don't even have to say goodbye.
You don't, just click.
Yeah. So you deal with scams, you deal with investigations, special investigations, maybe with elected officials. What else does the Attorney General's office do?
Well, as I said, we provide legal advice to all state agencies. Now, a lot of times folks don't understand that we don't make the decision for that agency. We give them legal advice. And as a consequence, they may follow our advice, they may not follow our advice. But I don't have the power to compel them to make a decision. For example, if DEQ makes a decision, someone will be upset. And they'll say, well, you should have required DEQ to do X, Y, or Z. The answer is, I don't have any authority to require DEQ to do that. I can give them advice, and they can follow that advice, or they can ignore that advice. But it's just like any other attorney, other than perhaps running down the hallway and tackling my clients. I really don't have any ability to compel them. And if I did tackle them, I could probably be charged with battery. So the answer is I don't have the ability to force them to make those decisions. I'm not, I'm their lawyer. I am not their, I can't require them to comply with the law. Now, I do everything I can to advise them, and sometimes those choices are just hard choices, and they have elements to it that I don't know or don't see in terms of the overall picture. My job is to look at the lawful responsibilities that we have and advise them of that.
And does it end with you being the top cop for the state? I mean, let's say you issue a decision about something. Can people appeal that, and who would they appeal that to?
Well, there's not really an appeal in that way.
It's final. It's the AG decided.
Well, except that I don't decide. That's the point. What I do is advise.
Advise.
And the agency will decide what it's going to do.
They can take your advice or not.
Or not. The agency then makes its choice, and then it creates a cause of action for the individuals that it affects. They can go to court and bring an action against the agency. So it's not really my decision. An interesting thing happened last 4th of July. I got a request from a legislator to give an opinion about the fireworks law. Now recognize that they're allowed me to ask that question, and by law, by statute, I have to answer that question. So I gave a recitation of what the law on fireworks provides. That was then delivered to a fire agency in Ada County, who then issued a statement saying the Attorney General declares fireworks illegal. I didn't declare any fireworks illegal. I don't have any authority to do that. The legislature has the authority to do that, and they did, but it wasn't the Attorney General who did that. All I'm doing is rendering an opinion about what the law says and quoting the statute and said this is what that means. And then there was another media agency who then said, well, the Attorney General is now backing away from his opinion. I didn't back away from my opinion. I don't have any authority to compel people to comply with the law. I don't have any authority to, in that instance. Mm-hmm. What I have the responsibility and duty to do is to render a legal opinion about what the law said, and that's what we did. I didn't declare things illegal, and I didn't declare things legal. I don't have the authority to do that.
You gave your interpretation of the law.
That's the law.
Yeah.
Here it is. Here's the statute. Read it.
Yeah. Let's talk about open records and rights of people. Do I have the right? Am I allowed to film a police officer during a traffic stop?
Are you doing that from a publicly accessible place?
Like in my car, cop pulls me over, can I pull out my phone and videotape?
Yes, you can. And in Idaho, recording an audio conversation requires one party to give consent for that. It's not a two-party consent state, it's a one-party consent state. So if you and I are together and I want to videotape you, I can. I don't have to tell you that. I can do it, right? And record the audio from that conversation. However, that doesn't mean that there aren't things that flow from that. The question is twofold. One, what's the legal requirement? And secondly, what's the practical implications of that? But also, if there's a third person here, and we're having a conversation, and that third person records our conversation, that may in fact be a violation. And why? Because neither you or I, who are participants in the conversation, have given authority for that person to record that conversation. Does that make sense?
Yep. How about a police report? Can I go to the courthouse and say, I want to see a police report?
The Public Records Act does provide for the release of certain information, including police reports, but there's a statutory mechanism. As you can imagine, during a criminal investigation, you don't want to disclose all of the elements of that investigation for a variety of reasons, including the fact that you generally don't try and tell the criminals you're trying to figure out what they're doing, okay, because it makes it more difficult. And secondly, you also have an obligation as a prosecutor. My duty is to seek justice. It is not to seek convictions. And so if I'm disclosing information in that process that poisons the jury pool, I have not been able to sustain the defendant's right to a fair trial. So you have both of those things that you have to comply with. So the question is, in any given circumstances, what are you entitled to? It's what the statutory provisions allow you to have. And at the conclusion of a case, then all of that material becomes available with certain exceptions. For example, if their bank account number is in a police report, we redact that, we black that out.
Social Security
number, because those are sensitive pieces of information that shouldn't be made publicly available, and yet it's in a police report. Does that make sense to you?
Absolutely. Let's talk about public meetings. Can I go into a city council meeting, county commissioners meeting, and record it with my phone?
Yes, typically you would want to ask them and that sort of thing, but there's not the open meeting law doesn't actually address the recording aspects of it. So generally I would say yes, there may be some specific statutory limitations. For example, you're not going to be able to walk in and videotape a court proceeding, okay?
Correct. That's the judge said, yeah, with the media too, it might be a little different.
Exactly. So you have authority to do that. Typically what you'd want to do is you'd want to just ask their permission for the very same reason, but it's a public meeting, but it's not the open meeting law that allows that or doesn't allow that. It really doesn't address the video recording. But typically you want to let them know, and oftentimes those public meetings are recorded anyway.
Yeah, they're broadcasted by the city or county themselves. Okay, so let's say can the mayor get together with 2 or 3 city council members and go have dinner together?
Yes.
Could the mayor get together with all of the city council and go have dinner together?
Yes.
And
what they cannot do is they cannot conduct city business under that circumstance.
So they could go and they could have an argument if they only discuss weddings and families and...
Yes. But the question is, do they have the self-discipline to stay within the confines of that requirement? And typically, if you and I are out talking, what are we going to talk about?
Right.
We're going to talk about business.
And so the minute that they're all out together, if they start to talk about the new projected water plan or whatnot, they could have violated that law.
They could have violated the open meeting law.
How many complaints do you get about things like that?
Well, we hear about that often, but recognize that under the open meeting law, the county prosecuting attorney has the enforcement responsibility with regard to local agencies, with the exception of the Board of County Commissioners. And then he must seek the appointment of a special prosecutor. That may be me, it may be another prosecutor, it may be any attorney who is admitted to the bar. With regard to state agencies, I have the enforcement responsibility regarding the open meeting law. So I don't have authority at the local level. That is the county prosecutor. So we typically hear about those kinds of things, but our open meeting law does not require no communication between the members of a board. It requires no communication when they're conducting business.
Mm-hmm. They also, cities and counties and state agencies too, required to post when they're going to meet.
Correct. It requires a notice of the meeting and a notice of the agenda. So both of those things are required separately.
And I recall you telling a story a year or 2 ago that that maybe one of those things did not happen, and the meeting was held, and you advised you probably should rehold the meeting.
Yeah, absolutely. In fact, there's now that event. I'll tell you what happened. We were going around the state and holding the state land board meeting. The members of the state land board are named in the Constitution. It's the governor, the superintendent of public instruction, the state controller, the secretary of state, and the attorney general. So by the fact that you're elected to that office, the Constitution says you serve on the land board. Our constitutionally mandated requirement is to obtain the maximum long-term financial return on state endowment lands for the purpose of supporting schools and other beneficiaries. So a very, very enclosed responsibility. Part of that is those lands are all over the state. So we were going around the state and holding land board meetings in the communities around the state so that the citizens could come in and they could observe the land board doing its business rather than just always holding them in Boise. So we were in Idaho Falls, and we were in Coeur d'Alene. And while we were at Coeur d'Alene, our meeting was going to be held in, I think, a library or something, I can't remember. And as I walked in, I noticed the meeting agenda and the notice of the meeting. So as we arrived, I said, I want to make certain that our meeting has been properly noticed and proper agenda notice been given. And so the staff said, yep, it's been given. So that's critical, because if it hadn't been given, it would be an illegal meeting. So I said, has the notice properly been given? And I was told, yes, it was. So we went ahead, gave our meeting and everything like that. All the motions, all the votes, everything done, all the minutes taken. And we then left and went back to Boise. And we got there, and the next morning I got a phone call. And the staff said, well, we told you that we had properly posted the meeting, but we hadn't. Well, I now have enforcement responsibility against myself and against everybody on the commission, because we've now participated in an illegal meeting because it had not been given proper notice. So what we did was we gave notice of that illegal, of a new meeting, properly posted, proper agenda. We went through everything that we had done, made all the motions, took the votes, took the minutes, did everything, and we included the minutes from our illegal meeting. I mean, there's no other way that you can fix that. That resulted in a statutory change to the open meeting law, so that in fact there is a process that follows that example and allows an entity to make a correction to its open meeting mistake.
And a big learning opportunity.
Big learning opportunity. I mean, you think what that makes you feel like. It wasn't that we intentionally did this.
Yeah.
In fact, we intended not to violate the law, but there was a violation. So what's the way you fix that? And the whole purpose of the open meeting law and the public records law actually is its performance. That's the issue. It's not to try and punish people. It's try to get us to perform properly and have our meetings in the open. And so that's what we were able to accomplish. I mean, we had to redo everything, but that's okay. And it was all done in accordance with the requirements of the law.
Do you think the general public knows the rights they have to this thing?
And the actual answer to that is some of them do, most and many of them don't. And that's why we participated in what's called the IDOG training, Idahoans for Openness in Government, in conjunction with the Attorney General's Office, in which, and other participants as well, in which we come to the community. We do this on a rotation, North Idaho, and then we start Eastern Idaho, and then Central Idaho, Western Idaho, and then North Idaho. We do that on a 4-year cycle. And in fact, I think in a week or two, we're going to be up north again. And it takes 3 hours. It's a long time. We've done probably 45 of these. I've been at every one. So you think 3 hours is long for you, and try that 45 times.
And there's role playing. I mean, you can act stuff out.
Yeah, exactly. So we take members of the community, members of the press and the media, and members of local government. We actually try and change their roles so that they have to be somebody else. And then we go through these scenarios so that we can try and train people, help them understand that there is in fact a sheet of music and that we're all singing from that sheet of music. We're not always going to agree on all of the issues, but if we understand what the basic rules are, it helps eliminate those kinds of controversies that can arise.
Yeah, I see the flyers. One of your staff members is holding up these little booklets.
Yeah.
We have them in our newsroom. And the public can get these, right?
Oh yeah, in fact, these are free.
So-
They're prepared by my office. We'll have a new set that will be done this year because of some changes. And it's the Idaho Public Records Law Manual, and it is the Idaho Open Meeting Law Manual. You can get them from us, just ask us for them. But also, these are available online on my website. They're free. And it goes through both of the laws. It has question and answers, it has examples. So it's well worth the effort to just take a few minutes and read through that. And if everybody knows and understands what those are, it's helpful. Because a lot of times the fights are about, well, this is what I think it ought to be and this is what I think it ought to be, when there's actually an answer in the middle that says, both of you, this is what you're supposed to do. So if we can get to the this is what you're supposed to do part, it will be much more helpful.
Yeah, there's often misunderstandings on both ends, as we have learned.
And one of the misunderstandings often is the FOIA, the Freedom of Information Act, which is a federal act. We don't operate under the rules of FOIA. We operate under the rules of the Idaho Open Meeting Law and the Idaho Public Records Act. Actually, FOIA relates to records. But we don't operate under the known federal FOIA rules. We operate under the specific state statute of the Idaho Public Records Act. And it's different. It's not entirely, very similar, but not entirely the same.
Are there any unusual or bizarre or crazy cases that you've, looking back since 2003, that you've had to deal with and address that have, left a memorable mark?
Well, there have been quite a number of them. Over the few weeks of my coming into office, we ended up filing criminal charges against as a special prosecutor, federal criminal charges against the city mayor of Boise and his human resource director and his chief of staff, and that was a really tough.
That's unusual.
That was a pretty tough case. I remember in that scenario, where there were competing press conferences, them down at the city hall, and we were in our offices. And along that line, there's a thing that I think is important, and that is that when we were involved in that in a criminal proceeding, there's a limitation on the things that I can say. It's an ethical requirement that I have as a prosecutor to maintain the jury pool, but to stay within the confines of the rules of ethics. So it's very limited on what we can say. So it's not that we're just trying to hide things, it's just that the rules of ethics and the duty that we have precludes us from saying everything that we know. We just can't. And there's a couple of investigations that we're involved in right now that are matters of high public interest, but we can't say anything about them because the rules preclude us from saying anything. So that was one of them that was an interesting and challenge. The whole Idaho place, the funding from the grant from the University of Idaho and the creation of the Water Place Tower, and that ended up being a really high-profile matter and was a really difficult challenge. And I've had a number of difficult criminal cases that we've been special prosecutor in, and a lot of notoriety about them, and our job is to call it based upon what the facts are and based upon what the law is. It's not a function for me to espouse my own political philosophy or whatever else. You have to know the law, you have to have a very good command of those facts, and you have to apply it against the statute as it's written. I don't get to rewrite the statute, that's what the legislature does, and then determine the outcome based upon that. And sometimes that becomes quite controversial, but you have to look at what are the specific facts, not what do I believe, what do I think, it's what I can prove. And I have an obligation to prove guilt beyond a reasonable doubt. And that means that's a very high burden. It's improper for me to bring an action. I'm precluded from bringing an action if I can't prove probable cause, and it's improper for me to bring an action if I can't prove guilt beyond a reasonable doubt.
Well, thank you very much for coming in here, Attorney General Wasden. There's a lot of helpful information on the website that we use every day, every week as media professionals that the public has access to, as Mr. Wasden mentioned. And we thank you for watching, and we hope you have a good week.